Good evening, everybody. Today's topic, as I've already mentioned, is regarding the victim compensation. Now, when I talk about victim compensation, it is a very important uh, provision because it in 19, if you talk about around 1970s, there was no provision for the victim compensation. So they were never ever there was no scope for victim compensation. Rather, that was the scenario at that time. So when I talk about victim compensation, as compared to developed countries of India, like UK, even Australia, victim compensation hasn't seen much light in today's time. Though we are a developing nation, we are one of the best economies of the world, but the victim compensation has always been ignored. And when I talk about victim compensation, the first thing which should strike your mind is Bilkis Yaqub's case. Now, this is a landmark case, and unfortunately, it is it shows how, because of delay and latches, criminal justice has affected our system, and the delay in getting even the justice to this lady in grief, who not only lost her elder girl child, but also was raped when she was 5 months pregnant. So when I talk about Bilki Bano's case, we need to understand the role and functions of criminal justice. Unfortunately, in our country, it is very complex and filled with lacunas. So, before we proceed, we must understand the meaning and definition of victim. So, when I talk about definition of victim, I talk about Article 1 of the UN Declaration of Basic Principle of Justice of Crime and Abuse Power, 1985. Now, this was UN. This was a declaration of basic principles of justice in the UN General Assembly in 1985. So it defines the term victim. So who's the victim? Victim is a person who individually or collectively have suffered harm, including physical or mental injury, emotional suffering, economic loss, or substantial impairment of their fundamental rights through acts or omissions that are in violation of criminal laws. When I will do with you the definitions of Indian Penal Code, the definition clause, those who have just joined this group, I must tell you that offense act includes, there is a definition of offense. And when I read the definition of act according to the Indian Penal Code, you will remember that act includes illegal omission. So whenever we talk about act, we also talk about illegal omission. Further, moving to Article 2 of the UN Declaration of 1985, it states that a person may be considered a victim regarding whether the perpetrator is identified. That is, even if the accused is not identified, prosecuted, or convicted, And regardless of familial relationship between the perpetrator and the victim, the word victim also includes immediate family or dependents of direct victim and persons who have suffered harm in intervening to assist victim in distress and to prevent victimization. So, in Indian context, the term victim has been defined. So, the term victim has been defined in Section 2, Clause WA of CRPC, which defines victim a person who has suffered any loss or injury caused by reason of the act or omission for which the accused person has been charged, and the expression victim includes his or her guardian or legal heir. So, thus, the victim is the person who has suffered any loss, injury, or death due to a particular act. This act could be emotional, psychological, physical, or monetary. So, the concept of fair trial is probably limited to the accused. So, this case, the Balkis Yaqub Rasool, I will refer it as Bilkis Banu's. It displays how concepts such as justice delivery, mechanism of the courts, and equality before the law function. So, the Constitution of India has several provisions which endorse the principle of victim compensation. For example, when you talk about directive principles of state, Part 4, it is also prescribed as a fundamental right in Part 3. So there are several provisions like Article 14, Article 21, Article 38, Article 39, Clause A, and 41, which endorse the principles of victim compensation in Constitution. But vis-a-vis, there are various other acts which talks about victim compensation. For example, Domestic Violence Act 2005, the Maintenance and Welfare of Parents and Senior Citizens Act 2007, Protection of Children from Sexual Offences Act 2012, which have been enacted by the Parliament of India for the victims of crime. So, as discussed with you earlier, that till 1970s, victims of crime were not considered as an essential part of criminal justice. So, as the time progressed, and because of the study of victimology, it has witnessed a huge growth and has also initiated changes in many countries, including India. So, a need to help a victim of crime was in mind of the legislature and judiciary, and thus emerged the concept of victim assistance services. Now, for victim compensation services, you must remember there was a committee formed by Government of India, by Ministry of Home Affairs in 2003. So the name of the committee was the Committee on Reforms of Criminal Justice. So the the term compensation again has been defined in Black's Law Dictionary. So what is a compensation? Compensation is an act which a court orders to be done, or money which a court or other tribunal orders to be paid by a person whose acts or omissions has caused loss or injury to another, in order that thereby the person damnified may receive equal value for his loss or be made with while in respect of his injury. So when I talk about this Bilkis Bano's case, unfortunately, it took 17 years. I repeat, it took 17 years, almost 73 prosecution witnesses, a nomadic life, no livelihood for a grant of exemplary compensation. So April 23rd, 2019 is marked as a historical win by legal fraternity and social activists. It was on this day that the Supreme Court of India granted the highest victim compensation to this gruesome rape and communal violence victim, to a mother who lost a child, who fought for justice. So, see the tyranny of the woman. So, there was one of the activists, if I remember, if you trace the history of this case, you will find there was an activist, social activist, maybe one of you, who helped this woman to go to the Supreme Court and get justice for her. Because police was refusing to register the case, and eventually this trial was transferred from state of Gujarat to state of Maharashtra. So let's talk about the facts of the case. So whenever you read a judgment, my friends, there are two parts of the judgment. One is opta dicta, and second is ratio decision. As I told you yesterday on my first lecture that law, it is mostly written in Latin language. So you should all be aware of these terminologies. So whenever you read a judgment, you will always know there are two parts of it. What is opta dicta? Opta dicta, I think I assume that all of you know. And ratio decidendi, that is the main judgment, the reasoning why that judgment has been derived. That reflects the ratio decidendi of it. So in Bilki's case, it is in 2002, Bilki Bano was living with her husband, and the name of the husband was Yaqub Rasool Patel, and a minor daughter, Saleha, aged 3.5 years. So on February 27, 2002, the members, if you remember those Gujarat riots, the members of Muslim community allegedly killed a large number of Hindu car sevas on account of burning the Sabarmati Express at Godhra station. What happened? This led to communal violence, which we all are aware. So Bilki Bano, along with her family members, fled her village of Radhikapur as there were incidents of arson and looting being reported by the people in their village. While on their way to a village called Sarjumai, a horde of 25 people carrying swords, lathis, and sickles attacked Bilki Banu and her family members. One of the attackers snatched Bilki Banu's 3.5-year-old child, and she was butchered to death in front of her eyes. Bilki Banu was raped by those men while she was 5 months pregnant, and her family members were killed on the spot while she was unconscious. So Bilki, after regaining consciousness, Bilki hid on a hilltop for her safety throughout the night, and an Adivasi woman helped her. Thereafter, she met a home guard who took her to police station in Limkheda. The police officials tried to cover up the case by refusing to file a complaint, then threatened her with dire consequences. They even tried to silence her to protect the accused. Not being someone who would lose hope easily, she filed a petition in Honorable Supreme Court of India with the help of a social media. Looking at the gravity of situation and the matter at hand, the Supreme Court transferred the trial from the state of Gujarat to state of Maharashtra. In trial court, charges were framed against 19 men, who also included 6 policemen and one government office and one government doctor who had tried to cover up the case. In 2008, the trial court convicted 11 men and sentenced them to life imprisonment, while 7 were acquitted due to lack of evidence. An appeal filed in the Bombay High Court, the High Court upheld the conviction of 11 men and set aside the acquittal of 7 men who were originally acquitted by the trial courts. So on April 23rd, 2019, Supreme Court in Bilki's case held the following. It held, taking into account the totality of the facts of the case, we are of the view that compensation of rupees 50 lakhs to be paid by the state government within 2 weeks from today. We deem it proper further to direct state government to provide the appellant with an employment under the state if she wishes so and is inclined, and also to offer her government accommodation at a place of a choice if she is willing to live in such accommodation. Thus, after a long battle of 17 years, Bilki Bano finally received compensation. In view of the pain, the agony, the trauma, and torture faced by her. Though compensation, accommodation, and job could not heal the scars of that horrible day, an attempt was made to help them fade. So here, I will say this failure of criminal justice. So in this case, it is a classic example where the failure of criminal justice was portrayed. Even though there was an offense covered under Section 376, Clause 2, Subsection E, and Clause G of Indian Penal Code, there was no record of crime registration due to overload of work. The summary report was on flimsy ground. There was no inquest report as required by law. Dead bodies were left unguarded. Dead bodies were left unguarded. Threats of administering poison injections were made. It took 6 years for 11 accused to be convicted. All these are errors rightly displayed the irregularity within our judicial system. It posed a question upon the sacred principles of factual justice. So, my dear friends, victim compensation, you will see now efforts have been made in Code of Criminal Procedure by virtue of 357 Clause A. It talks about victim compensations. So even there is a National Crime Record Bureau. So even the NCRB in 2016 shows only, I was seeing the figures, around 38,000 rapes were reported, wherever in the reality it was quite high. So there was a report published by Home Affairs. So prior to this compensation, in Bilki Bano's case, there was another case of Miss Z versus State of Bihar. Now this case is of 2017, where compensation as framed under Section 357A of CRPC was paid to the tune of around 13 lakhs. So being a rarest of rare cases, Bilki Banu's case, the compensation awarded was the highest till date, but obviously it is inadequate when compared to the trauma she had suffered. The amendment of CRPC in 2008, whereby Section 357A was inserted, which has laid down the victim compensation scheme. So you all are requested to read Section 357A of CRPC from the paper. Now let me talk about the international scenario vis-a-vis compensation. So I told you that process to avail compensation in India, it's very hideous as compared to UK, because in United Kingdom, within 12 months, compensation is awarded by Criminal Injuries Compensation Authority. So when I talk about India scenario vis-a-vis victim compensation, before the victim is granted compensation by the court, there exists a concept of interim compensation introduced under the ambit of victim support and assistance. In Bilkis Banu's case, state of Gujarat had offered an interim compensation of rupees 5 lakhs. This compensation was 1/10 of total compensation, which was granted to her. Thus, the efficacy of interim compensation remains out. So after directions by the Supreme Court, so that is why I say Supreme Court is also acts for judicial review. So judicial review is one of the most important topics by which the Honorable Supreme Court time and again has been giving recommendations, because at the end of the day, it is the Parliament who has to frame the law. The best example of judicial review I can say is also East Punjab Rent Act. Now, this East Punjab Rent Act, if you remember, if anybody remembers, this was enacted in way back in 1937 during World War II. And it was only made for 4 years. But unfortunately, our parliamentarians never had time to repeal that act and enact a new rent law. Now, rent law is a state legislation. So I must tell you that every state has a different rent law. Delhi latest rent law is there. Now, in rent law also, if you talk about the general topic, we also talk about uniform civil code. Not of hue and cry is being made by multinational companies, by IB companies, by, you know, you call it top 100 companies of the world, that this rent legislation should be universal throughout. So you should read about uniform civil code, and it is one of the latest topic these days. So rent law also, there is a there is a demand that it has to be universal throughout one nation, one law. So now talking about Bilki Bano's case, after Bilki Bano's case, central government to empower victims of crime and claim compensation under Section 357 and 357A, our justice system was amended. But although this is not the adequate relief which we seek, what we seek is speedy disposal of the cases, and interim compensation has to be worked out as soon as possible. So, if you remember, we are also having fast track courts. I think roughly there are around 400 plus fast track courts which have been set up to hear and dispose rape cases. So the aim of these fast track courts is to reduce the pendency and dispense speedy justice. But Balki Banu's case has questioned the efficacy of the courts below. So even if you remember, post Nirbhaya incident in 2012, Government of India established the Nirbhaya Fund in 2013 with an initial corpus of rupees 1,000. In 2015, to ward off criticism over non-utilization of Nirbhaya Fund, the Government of India formulated Central Victim Compensation Fund by amending CRPC and inserting Section 357A. So the central fund was also set up to streamline the compensation amount in various states for different categories. The Government of India issued guidelines for Central Victim Compensation Fund in 2015 and allocated rupees 200 crores from the Nirbhaya Fund to this scheme. So I will call it CVCF scheme, was aimed at harmonizing the state schemes. Under this scheme, the highest amount of rupees 20.10 crores was released to UP, followed by rupees 21.8 crores to Madhya Pradesh. After CRPC amendment, each and every state made its own victim compensation scheme, which has fixed structure of giving compensation. In public law remedy, the criminal justice recognized the shift from retribution to restitution when you talk about kinds of punishment in criminology. Section 357 of CRPC thus fulfills the idea of payment of compensation by them. The development of modern criminology, especially victim rights, has seen an expansion in substantive and procedural laws because of insertion of Section 357A of CRPC. Section 357C of CRPC talks about the treatment of victims. All victims must be treated by public and private hospital and cannot be refused treatment. It states as follows: all hospitals, public or private, whether run by the central government, the state government, local bodies, or any other person, shall immediately provide the first aid or medical treatment free of cost to the victims of any offense covered under Section 326A, 376, 376A, 376B, 376C, D, 376DA, or Section 376E of the Indian Penal Code, and shall immediately inform the police of such incident. Further, Section 166B of IPC talks about punishment for non-treatment of victims and states as follows: whoever, being in charge of a hospital, public or private, whether run by central government, the state government, local bodies, or any other person, contravenes the provisions of Section 357C of CRPC, shall be punished with a term imprisonment with a term which may extend to 1 year or with fine or with. These sections have been devised in such a manner so that they promote a right-based remedy. Because of such provisions, victims can be rehabilitated and victims can request the state or district legal services authority for award of compensation. So, as an aftermath of Nirbhaya's case, a writ petition titled Nipun Saxena versus Union of India in 2012 was filed in Supreme Court seeking immediate compensation of victim of sexual assault. The Supreme Court directed NALSA to set up a committee of about 4 to 5 persons who could prepare model rules for victim compensation for sexual offences and acid attacks. Compensation for women victims, survivors of sexual assaults and other crimes was a result of said writ petition. Under this scheme, a woman victim or her dependent, as the case may be, shall be eligible for grant of compensation from multiple schemes. However, compensation received by her in other schemes with regard to Section 357B CRPC shall be considered while deciding quantum in subsequent application. The court further directed that the states can grant higher compensation, but the compensation granted by the state cannot be lesser than what has been stated by NALSA in its scheme. In this scheme, a minimum compensation of rupees 5 lakhs and an upper limit of rupees 10 lakh is to be granted for loss of life. For victims of gang rape, a minimum compensation of rupees 5 lakh is to be granted, while an upper limit is rupees 10 lakhs. For victims of rape, minimum compensation of rupees 4 lakhs with an upper limit of rupees 7 lakhs is to be granted. Furthermore, victims for unnatural sex assault, a minimum compensation of rupees 4 lakhs and upper limit of rupees 5 lakh is to be granted. However, the implementation of these schemes is a major hurdle because lack of awareness. This is why I say knowledge is the biggest investment. Knowledge is the biggest investment. We all should share knowledge. And this lack of knowledge, believe me, if you put an RTA, you will find they are not complying all these schemes which have been ratified by the government and even been there in the order of the Honorable Supreme. So we must pro bono act for the welfare of these victims. We must find out from the state whether any steps have been taken for implementation of these guidelines. So friends, for today, I have discussed the victim compensation and I've told you that what are the various uh, steps taken by the government of India by enacting these schemes. Even we have talked about the amendment of Criminal Procedure Code and the landmark case of Bilki Banu's case. I hope it will be fruitful. It will add to your knowledge, and you must do justice to the people, and you must deliver justice. As at the end of the day, we are the custodians of justice to the normal person. Thanks. God bless you.